Hello, and thank you again for joining us today. My name is Ryan Sevcik, and I lead up the employment-based immigration work with Coley Jessen's Employment and Labor Group. This is our fifth segment in our six-part series regarding the H-1B lottery process. Over the past several weeks, myself and Stephanie Gratton have discussed the considerations and preparations that precede the submission of a registration in the H-1B lottery. Today, we'll focus on what you do once your registration is selected in that lottery. As many of you are likely aware, USCIS started the registration process last year, and as Stephanie mentioned last week, the USCIS currently conducts the lottery from among the timely submitted registrations. Employers will be notified of the selection of any registration beginning on April 1st, 2021. From the point of notification, the employer then has a period of 90 days in which to complete and submit the application to USCIS. There is not necessarily any requirement that the petition be submitted at any specific point during that 90-day period. However, timing may matter based on the facts of any specific case. An example of this is what is referred to as the cap gap period of continued employment authorization. This is potentially applicable for beneficiaries who are working on OPT authorization, but whose authorization expires between the period of April 1st through September 30th. As long as the cap subject H-1B petition is filed for someone in this situation prior to the expiration of their current OPT work authorization, then the work authorization is automatically extended from the identified date of expiration through September 30th. If approved, the H-1B work authorization would then commence on October 1st, thereby avoiding any break in employment authorization. Thus, for individuals in this situation, it is imperative that the H-1B petition be filed in a manner that ensures this cap gap coverage. Absent this or other timing considerations, the employer just needs to ensure that the H-1B petition is filed within that 90-day timeline. The analysis of the case and the approvability should have already been vetted prior to the submission of the registration, so the completing of the petition should hopefully be straightforward at this point. As we've discussed the last several weeks, the employer will need to prove that the offered position is H-1B caliber, that the beneficiary is qualified, and that the employer is offering appropriate wages for the position. The customary H-1B petition packet will have all of these portions thoroughly documented. An additional consideration when filing the H-1B petition is whether a change of status will be requested, or if it makes more sense to request consular notification of the approval. The change of status option means that if approved, the beneficiary's status will automatically change to that of the H-1B status on October 1st. Thus, there would be no need for international travel or issuance of an actual H-1B visa in the passport in this situation. On the other hand, the consular notification procedure means that a consulate abroad is notified of the approval, and the beneficiary will need to visit the consulate after approval in order to obtain his or her H-1B visa and then enter the United States in that status. Generally speaking, it is typical for individuals who are already physically in the United States in lawful status to request a change of status, and that those outside of the United States request consular notification. However, there can be nuances to these general rules depending on an individual's immigration history and other relevant factors. If the H-1B beneficiary has dependent family members in the United States, in other words, spouse and dependent children, then it will be necessary to consider whether a filing is needed for those family members in order to get them into H-4 status. H-4 is the derivative status for the H-1B category. Consideration should also be given as to whether the H-1B petition will be submitted with a request for premium processing. The current extra filing fee for premium processing is $2,500. Although steep, this fee does ensure a response, importantly, not necessarily an approval, within 15 calendar days of USCIS's receipt of the petition. Notably, USCIS often suspends the ability to request premium processing for cap subject H-1B petitions, so it'll be necessary to monitor announcements on that front. Even if initially suspended, there may be options to upgrade the petition to premium processing at a later date. Once the petition is submitted to USCIS, it effectively becomes a waiting game to hear back from the agency. Responses will either be an approval, a denial, or that dreaded request for evidence. Thank you again for joining us today. In our final segment next week, Stephanie Gratton will discuss the processing of the petition with USCIS, as well as pre- and post-approval issues to consider. Thanks again, and we'll see you next week.